Welcome to this explainer. Today, in exactly one sentence, we're going to master exactly how the law resolves unpaid debts at sea and why distinguishing between a standard claim and a powerful lien is absolutely critical to maritime rights. Here is our roadmap. We're going to cover an introduction to maritime claims, the power of maritime liens, comparing claims and liens, priority on judicial sale, leading Indian case law, and then we'll wrap it all up with a structured recap. Section 1. Introduction to Maritime Claims. So, let's start with the broad net of rights. What actually happens when a person or a business is owed money related to a ship's operation? Well, in plain language, if you have a recognized debt related to a ship, let's say you repaired it or you supplied it with goods, you have the legal right to have a court literally stop that ship from leaving the port. In law, this is precisely defined as a maritime claim. It's a claim falling within a defined, closed list of maritime activities that entitles the claimant to invoke Admiralty jurisdiction. And crucially, that includes the power of vessel arrest. Now let's look at how this developed. Internationally, this whole concept traces back to the 1952 Arrest Convention, which was later expanded by the 1999 Arrest Convention. But what's really interesting is how India adopted to this. For a very long time, India relied on these genuinely outdated colonial-era statutes, principally the 1890 Colonial Courts of Admiralty Act. But they finally ditched that old regime by adopting the Unified Admiralty Act of 2017, which closely follows that 1999 international framework. So, Section 4 of this 2017 Act provides a strict, closed list of these maritime claims. You can see the sheer variety here. It covers ownership and possession disputes, mortgages, loss or damage caused by a collision, cargo loss, and environmental damage. It also covers what we call necessaries, which are basically the goods and materials supplied for a vessel's operation, like fuel or food supplies, as well as crew wages and salvage. Bottom line, if your issue isn't on this specific list, you simply do not have a maritime claim. Section 2. The power of maritime liens. Okay, let's shift gears from a broad claim to a much narrower but incredibly powerful legal charge. I want you to think of this as an invisible, sticky debt. It attaches directly to the ship the very second an incident happens. You don't have to file paperwork, and you don't have to physically hold the property to create it. Legally, this is known as a maritime lien. By definition, it's a special charge on the vessel itself, arising automatically by operation of law upon a qualifying event, requiring absolutely no registration or possession. The really crucial point here is that a lien is a right in rem. Now, that's a Latin term, and it basically means you're taking action against the steel of the ship itself, not just asserting a personal claim against the person or the company who owned it. The ship itself essentially becomes the defendant in the lawsuit. Let's break down the 4 strict features that separate a powerful lien from an ordinary claim. First, it arises automatically. There is no formal step required. Second, and honestly, this is a remarkably powerful feature, it runs with the vessel. That means it survives a change of ownership. Even if a totally innocent, good faith buyer purchases the ship, they take it subject to that existing invisible lien. Third, it outranks even registered mortgages when a court is distributing money. And fourth, it is restricted to a very small, closed list of claims. Under English and Indian influence, only 5 traditional categories get this kind of immense power. 1. Salvage. 2. Damage done by a ship, like if there's a collision. 3. Seamen's and master's wages. 4. Master's disbursements, though this only applies in some jurisdictions. And 5. Bottomry and respondienta. Now, bottomry and respondienta were historic emergency loans secured against the ship or cargo. They're largely obsolete today, but they are still listed and taught academically, so you definitely need to know them. Section 3. Comparing claims and liens. This is a bit counterintuitive, but it's an absolutely essential comparison because it brilliantly illustrates why correct legal classification matters on a global scale. Supplying necessaries like fuel, repairs, or basic supplies gives you a standard maritime claim in India and the UK, so you have the right to arrest the ship, but you do not have a lien. However, under United States law, supplying those exact same necessaries grants you the immense power of a full maritime lien. It's a massive divergence in international law and a real game changer depending on where you are. Section 4. Priority on judicial sale. So, what happens when a court actually arrests and sells a ship, but the money generated just isn't enough to pay back everyone who is owed? Who gets paid first? Well, the law uses a strict descending hierarchy. Think of it like a waterfall. To distribute the funds, Step 1 goes to the costs of the arrest and the sale itself. Step 2 is where our maritime liens sit.
Notably, salvage often ranks absolutely first among those liens. Why? Because the salver's rescue action preserved the very money everyone else is now fighting over. Step 3 pays out registered mortgages, Step 4 goes to other standard maritime claims, and finally, Step 5 is for general unsecured claims.
Let's use a concrete example to really show this doctrine's teeth. Take unpaid crew wages, for example. Because this is a maritime lien, if the ship is sold to a bona fide purchaser, the crew can literally hunt down the vessel itself in the new owner's hands for payment. Conversely, consider an unpaid bunker fuel supplier. Because they only hold a maritime claim, if that ship is sold to a good faith buyer before the supplier takes legal action, the supplier loses the vessel as security entirely. They're just left with a personal claim against the old owner. Let's restate the precise rules so we can really anchor this doctrine in your mind. A maritime lien is an automatic right in rem that survives a change of ownership. It strictly runs with the ship against new owners. A maritime claim, conversely, demands immediate action. It is lost against the vessel if the ship is sold to a bona fide purchaser before action is taken. Section 5. Leading Indian Case Law. The absolute landmark precedent in this space is Liverpool and London SP&I Association Limited versus MVC Success 1. This was decided by the Supreme Court of India back in 2004. So picture this. A ship owner failed to pay insurance premiums to their protection and indemnity club. The central, massive legal issue the court had to decide was whether unpaid insurance premiums constituted necessaries that gave rise to a maritime claim, and consequently, whether the claimant could arrest a sister ship owned by the same company to secure that debt. Even though this case was decided well before the Unified 2017 Admiralty Act, its underlying reasoning remains entirely intact and relevant today. In resolving this dispute, the Supreme Court handed down 3 essential holdings that you absolutely must understand. First, it serves as the foundational authority on maritime lien priority. Second, it firmly establishes the core legal principles of in rem actions. Remember, those are actions directed strictly against the property itself. And third, it sets the precedent for sister ship arrest rules, outlining exactly when another vessel owned by the exact same entity can be detained. This case is crucial because it formed the bedrock of Indian admiralty reasoning that persists even under our modern statutes.
Section 6. Structured Recap.
Okay, let's bring everything together in a structured review to ensure you fully mastered this subject. We began with maritime claims, which are broad, closed list of activities allowing a vessel's arrest, and they are governed in India by Section 4 of the Admiralty Act 2017. We then narrowed it down to maritime liens, which are those automatic, highly powerful rights in rem restricted to just 5 traditional categories. And finally, we concluded with the priority doctrine, the strict hierarchy of judicial payout when a ship is sold, fundamentally anchored by the C Success 1 case of 2004. I'm going to leave you with a final thought to ponder as you continue your legal studies. As global maritime commerce evolves, will international law eventually unify the treatment of necessaries, or will jurisdictions, like the US and India, always remain deeply divided on exactly what debts deserve the ultimate power of a lien? Thank you so much for joining this explainer. Keep learning, and we'll see you next time.